U.S. Supreme Court made big news this morning, not by deciding to take on a case, but instead voting not to take up the case. It involved the city of Highland Park, a suburb of Chicago, which had enacted a ban on the sale or possession of certain types of long guns. And that ban had been challenged, but now the High Court will not take it on. Joining us to talk about it is Michael Hammond, who's legislative counsel at Gun Owners of America. Mr. Hammond, thank you for being with us.
Hello, Larry.
Hi. You're obviously disappointed about this, that only two justices, Clarence Thomas and Antonin Scalia, wanted to take on this case. What does this mean now for supporters of gun rights like yourself?
Well, two justices wrote a written dissent in which they said this reflects relegating the Second Amendment to second-class status. Interestingly, Roberts, presumably, who would have been the fourth vote necessary to bring it up, presumably voted not to grant cert, as we say in the law, or to grant a discretionary appeal to the Supreme Court. Now, the question is exactly why did Roberts do what he did? There are probably three big explanations. The first is that having handed down the Heller case saying that the Second Amendment is a individual right, not the right to a militia, Roberts doesn't have a particular interest in this area of the law as compared to other areas of the law, and alternatively, he wants to let it germinate at the lower court level. The second reason could be that the fourth vote on the Supreme Court would not have voted our way with respect to the Second Amendment question of the constitutionality of semi-autos. But it seems to me probably the most likely reason why we got the result we did is because Roberts and Scalia looked at Anthony Kennedy, who would be the swing vote with respect to this case if the court took it up, and determined that they weren't exactly sure how he was going to come out. And so this leaves us with sort of a roll of the dice. We'll see whether Hillary Clinton is the next president of the United States or Ted Cruz or Donald Trump or whoever. But whoever is the next president of the United States is going to get to nominate that swing vote to the Supreme Court, and at that point, it's going to be very interesting to see what happens.
So when you have bans like those that are in effect here in California on certain types of semi-automatic weapons, there's at this point that legal battle is settled. There's nowhere for those who hold your view to go, correct?
Not really. First of all, Barack Obama has used what's called the nuclear option in the Senate to pack most of the circuit courts of appeal, all except for two. But if a circuit court of appeal in another state were, for instance, to decide that the semi-auto ban was violative of the Second Amendment, all of a sudden you would have a circuit split, and that would put a lot more pressure on the Supreme Court to actually resolve that split.
Michael Hammond with us from Gun Owners of America. Also with us, Mike McLively, staff attorney at the Law Center to Prevent Gun Violence. Mr. McLively, good to have you with us.
Hi, Larry. Thanks for having me.
Is it your sense that this largely decides the issue pending any change of personnel on the court or not?
I think it does for now. We'll see. There's still a case dealing with the same issue coming out of the Fourth Circuit, so we'll see. The Supreme Court could potentially have another chance to look at this issue, but I think right now we've seen time and time again, and in fact almost 70 times since the Heller case was first decided in 2008, that the Supreme Court's been very unwilling to wade back into the Second Amendment issue, and they've basically been content to let the lower courts uphold a vast majority of common sense gun laws. And in the cases that we've tracked, more than 1,000 cases since 2008, the Second Amendment claim has been rejected by the courts nearly 93% of the time. So basically what the lower courts are saying is that reasonable regulation of firearms is totally compatible with the Second Amendment, and the Supreme Court, with the exception of Justices Scalia and Thomas, have been content to just let that ride. And so I think for now that's pretty much settled the issue, at least with respect to assault weapons and large capacity ammunition magazines.
Setting aside the larger capacity magazines, gun rights proponents say that really there are cosmetic differences, that typical hunting rifles and what are called assault rifles are really functionally the same thing, and it's kind of a discriminatory move against them because of what they look like, because they have a military appearance. Your response to that?
Well, my response would be it is difficult to draw lines on this issue. There's no question, and at some point a law might sweep in some weapons that people would argue are not as dangerous as others, but you have to draw the line somewhere, and the way most states have done it now are to choose specific models of firearms to prohibit, and then to have sort of a features test that's at least objective in the sense that you're prohibiting weapons that have military-style features that are designed specifically to allow for rapid fire, essentially for shooting the most number of people in the smallest amount of time possible. So yes, there might be some distinctions, but overall, we really have to take a stand against, what are offensive-minded weapons. And the reality is that most courts have agreed with this, too, that so many other alternatives are left available that people are not being limited in their ability to defend themselves in their homes. What's being taken off the table is military-style offensive weapons.
And we want to emphasize what you're calling military style. They're still not fully automatic weapons as you would have for soldiers.
That's right.
Mike McLively with us, Law Center to Prevent Gun Violence. Michael Hammond, Gun Owners of America. So, Mr. Hammond, back to you and this issue about distinguishing between certain types of weapons. Why do you see that as a Second Amendment issue? I mean, historically, hasn't the court held that local jurisdictions have the right to determine what their community standards are for allowable weapons?
Well, the court, by and large, hasn't held anything except what it held in the Heller case and in the McDonald case, incorporating the Second Amendment and applying it to the states. So we really haven't had the Supreme Court weigh in for some reason or another in terms of the rationality of California's semi-auto ban or anyone else's semi-auto ban. First of all, as you know, California is more or less gun control central. It has a semi-auto ban. It has a magazine ban. It has a limited handgun ban. It has universal background checks. And all that did in San Bernardino was to tell Saeed Farouk that he could go into that building with hundreds of people and do what he was going to do, and there was no chance that anyone was going to fire back. So I would argue that in places like California, Colorado, which had just enacted a universal background check and magazine ban that was no use in Colorado Springs, and Oregon, which had enacted a universal background check, which was useless in Roseburg, your gun control basically isn't helping and may actually be increasing the chances that you're going to have these circumstances of mass killings. The way, incidentally, that guns which are banned are normally defined is in terms, as you say, of cosmetic features, bayonet lugs, pistol grips. It's been a long time since anyone has gone into a center and started killing people with a bayonet. I was in the military. I was issued an M16 for the purpose of qualifying, and let me say, for those people who say these are military-style firearms, I would never go into a firefight with a semi-automatic firearm. So these have nothing to do with the most important feature of a military-style firearm, and that is that they fire automatically.
What about the cosmetics, though? Because you can make the argument that there is a cool factor here, as offensive as that may sound. The idea that someone who purchases one of these military-appearing weapons, even though they're not, they don't fire like a military weapon, that's part of the whole image that's being adopted in carrying out an attack on people. Is there an argument to be made that the cosmetics do in fact matter and can have an effect on behavior?
I don't think they matter a lot. I mean, that's one reason why people buy AR-15s, but the second reason is they're relatively light, easy to carry. If you're about 20% of them are used for hunting, and if you are a woman, they're a lot easier to carry, handle, disassemble, and clean than most other firearms which you could use. And so there are a variety of reasons why there are probably 8.5 million AR-15s in circulation now in America.
Mike McLively of the Law Center to Prevent Gun Violence. Earlier, we were talking about the president's address last night. Max Boot of the Council on Foreign Relations was with us, and he said, you know, when you've got the tens of millions of weapons that you've got in the United States, you know, gun control is, to paraphrase, essentially beside the point because there's such an ample supply. So what are the reasons, logically, in your view, for pushing for these kinds of controls on gun sales when essentially anybody who wants to get a gun is going to have ample ways of getting them?
Sure, and there are plenty of firearms in the United States, an estimated 300 million. So there are lots of weapons out there in circulation. But this brings me back to a point I wanted to make earlier, which is that when you're trying to create policy here, you can't look at individual circumstances and say, well, this tragedy happened in California and therefore the laws don't work. What we do at the Law Center is to look at gun death rates, and where we see strong gun laws, we see lower rates of gun deaths.